Welcome, everyone. Today's judgment pertains to a transfer petition. Many of you already know that in CPC and in CRPC as well, there is a provision wherein you can transfer your suit within districts. So, if you are, or let's say that you are in some place in West Bengal, maybe in Bakura, and you want to transfer it to Medinipur, it can be done. And for that, you need to approach High Court for it. Along with it, there is also a provision that allows you to transfer matters intrastates. So if you are in West Bengal and you want to transfer your case to uh, Bihar or maybe UP, that can also be done. But for that, you need to approach Supreme Court because Supreme Court is the authority that can decides on that. Now, this particular plaint originally it used to be or it was a transfer petition, but as in due course of time, you will know that it changed actually due to certain application. But originally, this particular judgment was a transfer petition before Supreme Court. Now, this particular transfer petition was filed by a victim, a so-called victim wife, for XYZ matter. We do not need to get into the factual details because that will not be very relevant at this time. But subsequently, the husband here, if you read this particular section, because before Supreme Court, there are two matters that they had to adjudicate, and the first was to grant a transfer of divorce petition from such and such place to such and such place. And the second question that they had to consider was whether the petitioner is entitled such and such, whether this court application by the filed by the respondent husband can exercise its power under Article 142 of the Constitution of India to grant a decree of divorce. Now, this was the uh, subsequent development preceding to that transfer application. The wife filed the transfer application to to transfer divorce petition to a different state. But subsequently, the husband, by using 142, Article 142 of Indian Constitution, asked for a divorce decree. Now, if you do not know what Article Indian Constitution Article 142 does, you can go to web. It will give you some idea on this, on details. But if I need to explain in a nutshell, High Court has many jurisdiction. This 142 is an instrument that is used by Supreme Court to do the complete justice of a case. So it's not a weapon that every day Supreme Court would use for the end of its justice. There are many ways. There are writ, there are curative petition, there are revisional application. There are many appeals, revisions, and all these things are there. The writ option is there. But alongside all those things, it also has an extraordinary power via this Article 142. And by using this, they can do pretty much everything. For example, as many of you know, that High Court or Supreme Court doesn't deal with factual details. It doesn't usually ask to get the evidence and the witness and all that. But if required, this 142 is can be used by Supreme Court to do that. Anyway, now let's get back to this judgment. So again, originally it was a transfer petition. Then the husband subsequently filed, asked for a decree for divorce, and Supreme Court had to decide whether uh, under 142 this divorce decree can be granted or not. Okay. Now, just an FYI, or I'll get back to maybe on this demand part later on. So, in order to decide this fact, whether under 142 a divorce decree can be granted or not, so the first court that Supreme Court referred is this one, the Shilpa Sailesh versus Varun Sreenivasan case, last year's judgment, and it's a very prominent judgment when it comes to deciding divorce decree under 142. And here, in this Shilpa Sailesh uh, judgment, they have taken a view that for again that end of justice to reduce the burden of litigation, because usually in the divorce case here in this particular section, if you read, the burden on the court, form listing paperwork, and often in divorce case there will be multiple litigations, the criminal charges, FIR, and all the civil litigation. So to remove this hurdle or burden from the petitioner or maybe respondent, they decided that yes, under 142, Supreme Court can adjudicate this matter, this divorce pertaining to divorce decree. So this, after this, the second case again, which is a similar case, Prakash Chandra Joshi versus Kuntal Prakash Chandra Joshi at Kuntal Vishaji Shah, and this is another precedent or another landmark judgment, you can say, in which it was decided that if the matter is such where the marriage is irreparable, it cannot be repaired, it's done, doomed to hell, let's say, to that degree. So in that case, even if one party uh, doesn't necessarily consent or ask for divorce, then also Supreme Court can grant a divorce decree. Here you can see wife in that case chose to this. So this is pertaining to this judgment, even though the wife was not there in the proceeding, but they got the ex parte judgment. So it becomes very clear actually from this that uh, Supreme Court can adjudicate matter pertaining to divorce decree under 142. Uh, Now there are some counter judgments as well, wherein the court viewed that it's not probably a wise decision when one party is not giving uh, consent to a divorce, and this is the example of this, R Srinivas Kumar versus R Smetha 2019 12 SCR judgment, and it said that unless there is a consent between both the parties, they will not adjudicate divorce. So both the sides, but one thing that Supreme Court got a clarity, because if you remember the first question that they were reflecting on this, whether they can adjudicate this matter related to this divorce decree or not, and the answer that they uh, found through all this judgment that yes, they can. Okay. Now, sorry, this is another judgment, Munish Kakkar versus Nidhi Kakkar, SCR 169, and it says no doubt there is no consent of the respondent, but There is also a real terms no willingness of the parties, including the respondent, to live together. There are only bitter memories and angst against each other. This angst has got extended in the case of respondent to somehow not permit the appellant to get a decree of divorce and live his life, forgetting that both parties would be able to live their lives in a better manner. So they're basically saying that if the scope of mutual reconciliation is next to none, then there is no point keeping them together, binding them, because uh, when it comes to divorce, marriage, and all these things, they mostly involve, I mean, human psyche, or you can say result of human emotion. And legislation or rules and regulation that have been constructed by society, they have very little effect on them. So basically, considering that human aspect, or a very practical, I would say, aspect of human behavioral phenomena. So at the end, they decide to, if I go at the end, at the end, in the conclusion section, they allowed that petition under 142 for divorce decree, along with some maintenance, or you can say compensation. I do not know whether to call it a maintenance or compensation, but she was apparently uh, given one-time settlement of 12 crore. And with respect to this aspect of alimony, I'm going to make a subsequent video. Uh, uh, so there I have a lot to talk about this new norm, this alimony. Anyway, so that will be a separate topic. But eventually, uh, the two questions that Supreme Court was two questions that Supreme Court was trying to answer, whether they would transfer the matter. So the answer, they didn't decide to transfer because the relationship basically broke down. You need to read the factual details, because I can show you little bit about what was going on. So the wife filed an FIR. There was a counter cases filed by the respondent, and I think this is one case where you will see that the respondent husband filed three divorce cases. I mean, against the same wife, though in a different context and in different manner, because logically you cannot file three divorce cases. Uh, so based on all these history uh, that were behind them, Supreme Court decided not to, extend this game of litigation any further, and decided to grant divorce under 142. Thank you.